My name is Dave Michels, and I teach the Cloud Computing Law module at Queen Mary University of London. I'm also a researcher with the Cloud Legal Project, as well as a guest teacher at the London School of Economics. Now, in this course, we discuss the legal and regulatory implications of cloud services. See, in the past, we all stored and processed data primarily on our own local computing devices, such as laptops and smartphones. But today, our data are often stored on remote cloud servers operated by third-party service providers like Amazon, Microsoft, and Google. For example, if you're anything like me, you store your photographs in Apple iCloud, your Word documents in Microsoft SharePoint, and you send and receive emails using Gmail. As a result, our data increasingly reside on third-party servers at data centers located around the world. And this change has resulted in a fundamental shift in who owns, operates, and controls the computing resources on which we all rely. And that raises important legal and regulatory questions. For instance, first, who can access the data you store in the cloud? And second, who is responsible for securing that data? Or third, what happens if a foreign government orders your cloud provider to disclose your sensitive personal data? In this course, we answer these questions by looking at cloud services from a range of legal and regulatory perspectives. In particular, we cover the laws of contract, data protection, competition, and cybersecurity, as well as the rules that govern when a foreign government can access data stored in the cloud. Now, this is a team-taught module, which means you get to hear from various expert members of the Cloud Legal Project, which is a world-leading research team funded by Microsoft. The teaching team varies from year to year, and has in the past included professors like Ian Walden and Christopher Millard, as well as practitioners like Neve Gleeson. The classes are held in person, and combine expert presentations with group discussions of hypothetical case studies. For example, we might discuss a scenario in which a fire at a cloud data center leads to the loss of customer data. Is the customer then entitled to compensation from the cloud provider? Working in small groups with fellow students, you'll answer that question, including by analyzing the terms of standard cloud contracts. At the end of the course, you will be examined by means of an online written exam. The exam will test your ability to apply the law to a scenario involving cloud services. You'll also need to write a short essay on a relevant policy issue. To help you prepare, we provide exams from previous years, and we'll have a dedicated exam prep workshop at the end of the course. This course is relevant to anyone with an interest in the practice of IT law. It's also helpful to anyone working in data protection compliance, as we apply the concepts and principles of the GDPR to cloud scenarios. Finally, the course is relevant to anyone pursuing a career in policy development, as we review the ongoing debates about competition in cloud markets, cybersecurity standards, and questions of digital or technology sovereignty.